very well, National Security Attorney Brad Moss. Brad, welcome back to Lights On.
Absolutely. Happy to rejoin you.
Yeah, I mean, we just have a plethora of activity this week to discuss, don't we, on the Trump legal front? We have news today about different rulings as far as delays, but I really want to start off with this kind of outrageous motion that Donald Trump filed yesterday in the DC case before Tanya Chutkan, asking for an outright dismissal of the election interference case. Can you bring us up to speed on this, Brad?
Sure. So Donald Trump finally did what we were all kind of expecting him to do. He filed to dismiss dismiss the criminal charges in DC brought by Jack Smith on the basis that he's covered by presidential immunity. This was the abstract constitutional argument we were anticipating. We weren't really sure if he was going to try it. This was basically Richard Nixon's defense. This was when the president does it, it means it's not illegal. What Donald Trump is arguing is that everything he did that's outlined in the indictment, all the actions he took with respect to the Justice Department, with respect to interacting with the state officials in the various swing states where he was trying to get the votes changed, his interactions with Mike Pence and various members within the vice president's office, all of that was done in the context of his official duties. It didn't matter if there was a blending between official and personal, and therefore he is immune from prosecution. There is no precedent for this. And this is the problem. And this is what we were always anticipating would be part of the issue of it bringing this indictment is there's never been an indictment of a former president for actions taken while in office. So there's no clear guideposts for the Justice Department on what can and can't be done. This is going to almost certainly go up to the Supreme Court at some point to determine the scope of immunity for a president for what he or she does while in office.
It's really outrageous, though, isn't it, Brad? I mean, he's basically making the argument that you can't, well, he already made the argument when he was president. You can't prosecute me while I'm president. The Justice Department backed him on that with that, legal memo that was guiding their, refusal to prosecute him while he was president. Now he's saying you can't prosecute me after I'm president. It's basically, I know it's called a motion to dismiss, but I really think it's more like a motion for dictatorship. I mean, it's like, this is how you can be an autocrat or a king in this country and never have accountability and literally he wasn't acting in his official capacity. He was abusing his official capacity. That's the whole indictment. He was abusing his official capacity to literally undermine American democracy.
Yeah, it's rather terrifying, the idea that it would place if this precedent, if it were established by Donald Trump, would place the future presidents above the law. They could never be held accountable if they committed separate criminal acts while in office. And if you think back, for those who remember the 1970s, remember Richard Nixon's legal fights, when Nixon's lawyers went before the courts trying to prevent the independent counsel from getting access to the audio tapes, one of the arguments they essentially made to the court was, my client wants you to believe and wants you to conclude that as president, he is essentially a monarch. He's King Louis XIV with all those same rights and privileges for 4-year increments. Courts didn't agree with that. The Supreme Court in 1974 rejected this premise, said a sitting president could be subject to criminal processes such as a grand jury subpoena while in office. And just 3 years ago, the Supreme Court again rejected this in the context of state prosecutions, saying the Manhattan DA could issue a criminal subpoena to Donald Trump while he was still in office to get access to copies of his tax returns. So if an incumbent president can be subject to criminal processes, both from the federal and state level, there's no reason to conclude a former president cannot be subject to that criminal process for what they did while in office, assuming it has to do with a separate criminal act independent of their normal duties.
Yeah, Brad. And another thing that his lawyers try to argue in this motion is that the mechanism for holding him accountable for that egregious behavior would have been impeachment. And they argue that, well, he was acquitted, even though a majority of the Senate voted to convict him. Of course, it didn't reach that 2/3 threshold. And of course, it reminded me of the words of Mitch McConnell in his excuse not to vote for impeachment, saying that our justice system really held the key to holding Donald Trump accountable. Let's play that clip.
President Trump is still liable for everything he did while he was in office as an ordinary citizen. Unless the statute of limitations is run, still liable for everything he did while he was in office. didn't get away with anything yet. We have a criminal justice system in this country. We have civil litigation. And former presidents are not immune from being accountable by either one.
So there's Mitch McConnell saying, courts, please do what we don't have the spine to do, please.
Hey, the old turtle got it right there. Look, that is very true what Mitch McConnell said. Both the civil and criminal processes can hold a former president to account. We've already seen that in the civil context. There were the civil lawsuits brought by members of Congress against Donald Trump for his comments and his actions on January 6th. So far, that has survived claims of presidential immunity. That's obviously still on appeal. That's something that Trump's lawyers try to proactively address in their motion to dismiss the criminal charges. But from the criminal context, the notion that the only way to hold accountable a president is strictly through the political system, is strictly through Congress and the impeachment process is laughable. There's nothing in the Constitution that suggests that's the only mechanism to hold accountable the person who held the office of the president. There's no reason to believe, there's nothing in case law, there's nothing in the Constitution that suggests the person holding that office is above and not subject to the criminal judicial process. That's why ultimately I expect Judge Chutkan will reject this motion. I absolutely assume Donald Trump will appeal. Whichever side loses the motion is going to appeal. And I absolutely expect this at some point to get up to the Supreme Court. What is not clear is, one, if Supreme Court will even take up the case. It's entirely possible they'll decline. But two, even if they do, I don't necessarily see a five votes that Donald Trump can get on this argument. There's at least two of his appointees, Judge Kavanaugh and Judge Barrett, I don't see as even siding with his argument given their own past work and their own past experience on this matter. I expect he will lose this argument.
That's very good news. He deserves to lose it. And of course, this is all part of his strategy in one respect, trying to get charges dismissed, and another just trying to run out the clock, delay. He's been doing this repeatedly this week, trying to have cases dismissed, and then we're getting answers on motions he's filed for delays. In one instance in DC, Judge Tanya Chutkan largely rejected his request to delay the DC filing and trial deadlines, but gave him a little bit of additional time to file some motions. She also rejected his order to declassify a version of the government SIPA filing. Now, on the other hand, you have Judge Eileen Cannon in Florida, who today issued an indefinite stay on their Trump's lawyers' deadlines for the SIPA filings. And correct me if I'm wrong, this is indefinite pending her decision on Trump's motion to extend the trial date beyond the 2024 election. So really, we don't even know if this is on track right now. It could go off the rails.
Yeah, so the case in Florida with Judge Cannon, it's interesting to watch the difference between her and Judge Chutkan in terms of the idea of experience and understanding of these types of national security cases. A lot of us have beaten up on Judge Cannon a bit. There's been a lot of concern about whether or not she's, trying to put her, thumb on the scale for Donald Trump. I think some of what she's been doing is based more on inexperience and not necessarily knowing how this process works. So she put this temporary stay on the existing SIPA deadlines. She wants to, resolve the motions. The big question is, what does she say? What does she conclude in her ruling, and how long does it take? If this comes out in a week or so and she resolves the issue, no harm, no foul. That case isn't even supposed to go to trial until May. But if she takes, a month or so just to resolve the issue and it gets all caught up in, the weeds, it could throw a real wrench into the entire process. So you wonder, part of as she's looking over the issue now over the next week or so, will she look to Judge Chutkan's analysis that came out today for guidance, particularly when it comes to SIPA with respect to some of President Trump's arguments? There's obviously a lot more classified information at issue in the Mar-a-Lago case. It's far more critical to the presentation from the indictment. But some of the former president's arguments and his attempt to try to circumvent the SIPA procedures is more or less ridiculous. And Judge Chutkan pretty much called him out on it in her ruling today, basically saying none of this is what the text of this other statute allows. It's not what the case law says. I'll give you a chance to show me how it is, but more or less, I'm rejecting entirely your arguments. I'm not making the government put their stuff on the public docket. It's classified. It's going to remain under seal, and you're not getting these crazy extensions. I'll give you an extra, couple of weeks for this part or that part, but you're not getting 2 months just to file, a pretrial motion to dismiss. You got maybe an extra 2 weeks. You are more than capable of doing it now. And I think, when Judge Kennett comes out with a ruling, I would be interested to see to what extent she relies on that for guidance in terms of how she frames her analysis on these rather similar arguments that Trump made down in Florida.
Yeah, she really does need guidance, doesn't she, Brad? I mean, she is not.
I mean, she hasn't. I mean, let's be fair. I think she's younger than me, and she doesn't have a whole lot of background in this, which isn't her fault. Most judges, especially outside the D.C. area, have very little experience with these types of cases, and would be looking oftentimes to judges from the D.C. area and from New York for guidance in terms of how to approach it. It's particularly unfortunate for Judge Cannon in the sense that it's a very high-profile case, of course. There's the issue of the pending election that's 13 months away. She knows she's under a political and public microscope on that front, and she has to know to an extent that her legacy will more or less be framed by how she handles this case. That being said, she's a judge. She's so far acted fully within her discretion. She hasn't broken any rules that I've seen in terms of how she's approached it. The question is, does her decision, do the time frame for her to reach these decisions, inadvertently or not, give Donald Trump more wiggle room to push that case off until after the election? We'll have to see. Like I said, if she comes out with a ruling next week on this, no harm, no foul, whatever. I don't care about the temporary stay. But if we're in November and she still hasn't ruled,